sir. Could you elaborate your point? Why did you say that this decision had some hidden agenda, while the mainstream media is celebrating this judgment as a great decision which will usher in a new movement for equality and inclusiveness within the SC and ST community?
Thank you, Abhay. Thank you so much for talking to me. I think the answer lies in the very question that you asked. When you gave me a justification and then you said that the mainstream media is celebrating an order which has come on the matter of reservation, when the mainstream media starts celebrating it, there is something to be very critical of. Now, I would like to place it, the judgment, in the context of two different angles. One angle is coming from the demand which is generated by the movement itself, and the other angle which is about understanding how that demand will be translated and enacted in the institutional framework. Now, when I look at the judgment only from the angle of the demand of the movement, I feel happy about it that the demand of the movement has been accepted and understood. That was my earlier position which I wrote in 2010. But when I look at it in the post, my later experience with the institutions, the functioning of the institution, the way reservation is implemented, the way reservation is attempted to be blocked, that is where I become little critical about the way this judgment will have impact on the overall functioning of the judgment.
So you are trying to say that the judgment has implementation parts which may be formulated, but your experience earlier tells you that it might be misused. Could you say something more about that?
Yes, let me give you an example. The very fact that the Supreme Court took more than 20 years almost, or 16 to 20 years to come to this conclusion, which is, you can see there are some rhetoric, there are some, some evidence based, and there are some rhetoric also. Data which is kind of available about, inequalities within the scheduled caste. Yet the Supreme Court did not take any step necessary to really substantiate the point that it was trying to make. Makes me critical of their intention, that without actually investing into it was asked a very important question. Now, if the Supreme Court is only saying that I am only looking at the interpretation of the law, is a question of law, and therefore I am giving this subclassification, I have no problem with that, right, because it is limiting itself to the question of law. But if you really look at the judgment in effectively actually is trying to overreach, trying to go beyond what was asked of it. And hence, in that context, it is important that when something is coming from the Supreme Court which is about a subclassification without really understand the demand and the way that those demands should be met, I think my own experience working in the institutions has shown me that it is very difficult. The implementation of reservation system, the way it has been completely flawed, the way it has been dismantled in various ways by institutions, by the state, that's a very important part. And I cannot look at the judgment only at its face value. I will have to look at the judgment and compare it with the existing system, existing framework into which reservation is implemented. And there I see that there is a high chance that this kind of judgment will be misused by the state institutions to further dilute the overall system of reservation, and I see that as a threat.
About the Supreme Court judgment, there is a lot of confusion. Some scholars argue, Professor Yogendra Yadav was here, who spoke with you yesterday. he said that judgment is all about a limited question whether a state has power to subclassify SC and ST reservation. Beyond that, there is nothing more in that judgment. But then some people are also arguing that how the subclassification will be done, and the 4 judges have spoken in favor of the creamy layer within the SC and ST community. Now some sections are saying no, it is all about classification, creamy layer is not justified in SC and ST community. Why there is so much confusion with this judgment, and how do you look at as an expert?
You know, absolutely, you are very true. That there is an intention to create this confusion. It is very clear that, you know, when something comes from the Supreme Court in a written framework, of course there is the effective part of it, which is people say that, oh, only this much has been given as an order, and it was the question of law. But then the question is that why did it try to overreach and comment upon? And that's the question of creamy layer. And mind you, if 4 judges are talking about something in a in a situation where it was not even asked to them, when it was not even asked to be commented upon, then the Supreme Court justice is talking about creamy layer within the scheduled caste and scheduled tribes is nothing but an overreach, and that cannot be understood as not part of this judgment. So let us be very clear. Yes, on the question of law, it is a matter of interpretation whether states can subclassify or not. If it had just remained limited to that and had said that ki, you know, in the matter of law this is fine, but if the Supreme Court had gone little beyond that, if you do this, will you really be able to achieve the objective that you are trying to subclassify with? You had 16 years with you. Did you really get into that question that if the demand is about equality, how are you going to create more equality by, you know, dividing the share that you have given, a small portion of share that you have given? And it is the Supreme Court which has shown, and it's the whole judiciary which has shown you know, great reluctance, and I am telling it that I used the word yesterday called torturous reluctance about understanding that India is a caste society. Why I say torturous? Because it has inflicted huge amount of pain on a large section of the society, when the Supreme Courts had a great difficulty in understanding the idea and the debate on reservation, why it was needed. Right? So basically it has been the demand of the movement, and it has never come as something which has been benevolently given either by the Supreme Court or by the state. It has been the demand of the movement.
So do you fear that creamy layer is going to be imposed on SC and ST community?
Of course there is a strong fear. There is a strong fear, and I'm telling you what my fear is. My fear is that you know, while the subclassification debate will be pushed to the state, that, oh no, it is about for the states to decide nationally, you know, the ruling regime is going to, I mean, at the moment it might have clarified that there is no creamy layer, it is unconstitutional, which is very true, but they are soon going to play this role. They are soon going to sort of use this as a major sort of a, you know, and this will be a big threat to the whole debate and whole idea of, you know,
you have worked
action.
About the SC community at different regions. Some people argue that there is a presence of creamy layer within the SC community. What is your research? Do you support that claim, or is it just the rumor?
No, so think about creamy layer within a society or within the small community, within a more you know historically deprived section is actually an absurdity. Right? So I don't want to get into that. I mean, I don't want to get into even an engagement whether that is justified or not, because it is totally absurdity in terms of thinking about a creamy layer within the scheduled.
But sometimes if any scholar would give you data that here is JNU, suppose it has got 1000 let's say SC and ST students, and out of them, if they give you the data that 600 or 700 SC and ST students come from few benefited caste of the SC and ST community, does that argument pave the way for subclassification or not?
Of course not.
Why, sir?
The reason being the following. that as I said, if the intention is to create more equality, then you have to look for how to generate more equality, how to generate more resources which can bring in more equality. And I think for that, as I had suggested yesterday, if at all Supreme Court is interested, and I think the movement will have to also think at large. As I said in the beginning, I am not trying to deny and negate the demand of the movement. There are genuine demands which is coming from the ground about their needs being addressed. But is sub-classification the only way and the unique way to address it, is the question that I am asking. And therefore, I think for me what I see as a best solution about addressing that, how do you see this difference? I think and once again I then go back to the judiciary, because even this cap of 50% which you say on reservation, when the population share is much higher, if you are putting a cap of 50%, you are necessarily trying to squeeze them. My argument is that if you really want to address inequality, why can't we increase the percentage of reservation? You did it in the case of EWS. Did you not go beyond that? You went beyond that, right? So why can't we increase the percentage of reservation and then say, and then let the movement together demand this, that you increase the cap, you increase say another 7% quota, and you say that then because now it will increase from 22% to 30%, right, 29%, and then you say that there we will try to subclassify. Then then you are not sort of trying to take away something, and because it is a historical phenomena, and of course in that practice you will see that there will be a distinction between different groups. And if you really want to address the question, I think there are several, and that has been the argument, several other mechanisms to address that. But is subclassification the only way? Is the moment I want everyone to see and reflect upon.
So you have said that sub-classification is not the best solution to address so-called inequality within the SC and ST community, and you also question the intentions of the court, that why court has opposed increasing the quota for the marginalized community. You have understood this question so well. But when it comes to the left parties, I have seen the statement of the CPI and CPM also, which have welcomed the decision. And I think as far as CPI ML's position is concerned, I have read their Politburo statement many times. But I was not able to understand whether it is for the sub-categorization or whether it is against it. I mean to say that CPI ML's position is not very clear. So my argument is, you are very clear. You could see the intentions behind all these things, but why the left parties which claim to represent the marginalized community, why they are not opposing it in such a clear terms as Professor Avinash Kumar is speaking?
Well, I mean, I'm not speaking on behalf of any political party.
I just scholar your view.
Yes, and neither am I privy to the discussions or whatever happening in any political party, but I want to caution you, because when you said that I am speaking either or, I don't want to see it as a debate between either for or against. I am asking all of us to think constructively about, as I said, if you really look at the demand of the movement, there is something that we need to do. And if you look at the solution being imposed, I am saying I think we need to rethink. Is the solution being imposed the best way, the best solution? I think that is not the best solution. The solution could actually become a good solution only if you allow the expansion of the limited number of quota that you are providing to the community specific. And I think it is a constitutionally permissible demand which can come from the movement. That is what the Tamil Nadu had done in the case of the OBC classification. When they wanted to have sub-classification of the OBC reservation, they did not sub-classify within the existing quota system. They actually demanded that we will increase the quota system, then we will, and hence you will see that even after Indra Shawni judgment, Tamil Nadu went to the parliament and it said that please allow this 69% reservation and then put this in the Schedule 9, so that then it becomes outside the purview of judicial review. And that is where I am asking the movement, and all of us have to constructively think, what is the need of the hour? I am saying, do we say that the demand which is coming from the movement, we should completely snub it away as a political conspiracy? No, not at all. There is a certain essential need to address that. But is this the best way to address it? I am saying no. So I am not about for or against. I am trying to talk about a more constructive approach, and I think if left parties are trying to build that constructive approach, there is no harm in that.
So, sir, the last question. Professor Avinash Kumar from Center for Informal Studies and Labor Studies in JNU has worked on the marginalized community for long. Sir, if political parties claiming to uphold the ideology of social justice and left, or any democratic minded persons is listening to your interview, what would be your advice? What would you say from your experience, your research? What is the way out? Sir, the final question.
Well, as I said, that there is already a provision which has been utilized in the case of Tamil Nadu, and I think one should look at that. But more importantly, I am saying that this judgment should not be used as a tool to divide the community, which is what my fear is. And when I am saying divide the community, it is about placing the aspiration of one against the other, and that's the real challenge that all of us, all progressive people, all progressive group, Dalit movement, tribal movement will have to, the left movement will have to come together and think about that constructive approach in which one is not pitted against the other, and that's the real challenge that we have for today.
Sir, thank you very much for sharing your views.
Thank you so much, Abhay.